Hey, welcome to a Wiser Retirement podcast. Leaving a financial legacy isn't something that happens by accident. It takes planning. We've put together a guide with 7 steps to leave a financial legacy and have made it available for free on our website. This guide covers designing your legacy, estate planning, financial education, and protecting your legacy. The link to download 7 steps to leave a financial legacy is listed in the episode description, or you can go to wiserinvestor.com, scroll to the bottom, and find it there. Now on to today's episode.
Welcome to a Wiser Retirement Podcast. We believe the best financial advice should always be conflict-free. I'm your host, Casey Smith. With me today is my co-host, Brad Lyons, and we are joined today by Doug Butler. Doug is the attorney at Moore Ingram Johnson Steele. He's part of the estate planning group, as well as a partner within the firm's corporate and transactional law practice. How you doing, Doug?
Doing well. Thanks for having me.
Glad to have you here, Brad.
Hi, Casey.
We're back in studio.
Yes, we are.
This is
It's like old home week.
right. Well, I've been traveling, so that's forced us into some Zoom recordings, and then we've gone almost a month with no AC here at the Wiser Global Headquarters.
Wow.
So it got up to 87. I think it was last week, and
I was in here on Monday, and it was 87 degrees.
I sent everyone home. Brad came in anyway. I'm not sure what happened there.
It was nice and quiet.
You were thinking hot yoga, Brad? Is that what you were thinking?
Did you bring a fan at least, or some cool rags?
But an ice pack.
Yeah, an ice pack. Ice down.
So yeah, finally they did not replace the unit. So unfortunately, we're going to have to go through another period of no AC. But hopefully, we'll do that in the fall when we don't need it anymore.
Oh yeah.
But
hopefully the heat will work.
The struggles of being a tenant have become very clear. But yeah, happy to be back here. Happy to have LJ live. He's behind the camera here doing our video recording. Hadley's in the Bahamas right now. I saw her swimming with a pig on Facebook yesterday. So, we do not have our marketing guru Hadley here with us, so we get to do anything we want. This is pretty cool.
It is.
So we're
unsupervised.
We invited Doug over.
All right.
I think he brought a 6-pack with him. So
yep.
You know, it's hard to find attorneys that will do
no AC. We're going to need a 6-pack.
That's right.
Cool, right?
It's hard to find attorneys that will actually do podcasts.
Really?
It's surprising to me because I feel like attorneys like to hear themselves speak, but yet
they do. But we don't get to bill for it here, so I guess that's probably why.
Oh, we're not on the clock. That's what it is. We're not on the clock.
Yeah.
Okay.
If you can't bill, then we're known for dragging things out because we get to bill by the minute. So,
that's true. Yeah.
But no billables and no talking.
There was a slip and fall case I was involved in one time in our private equity fund many years ago, and I had to go all the way over to Charleston. It was a horrible trip. Actually, it wasn't enjoyable at all. To do the mediation for this thing, the guy was asking for like $1 million. I think he got like 10 grand or something. But nothing happened all day long until about 4 p.m. And at 4 p.m. on a Friday there was this just urgency to complete this. And within an hour, we did a whole day's worth of work.
And hammered it out. Yeah.
And got everything negotiated amongst, I think, like 5 parties. It was crazy. But yeah, I've learned a lot about how that works on billable hours.
Yeah, well, the litigators, they have a whole nother method to their madness. But
that's right.
I chose transactional to stay away from.
We won't pick on you too much.
Yeah, it's quite all right.
We'll stop there. All right, so this quarter's theme has been legacy planning, and Brad and I have had some great interviews this week, and we use a couple of firms here at Wiser for estate planning. Doug is one of those referrals that get quite a bit of our business, and I've been doing this for 22 years, personal financial planning, and I've met all types of attorneys, and I'd say that as our firm has gotten larger, that we've been able to partner with much better quality attorneys. I don't know why. Maybe it was just the network as a smaller advisor when I was starting out. But really, I mean, there's 2 firms in town that I consider the best firms. Morgan Johnson Steele is one of them. Gregory Doyle Calhoun Rogers is another one. Now, you guys might be competitors in some sense, but
We could play.
when
It's collegial.
It's collegial.
But-
we play
but-
it nice in the sandbox. Yeah.
to compare to the other firms that I feel like we have to choose from, I think you guys do it well. What I've learned is in choosing an estate planning attorney, if you go to a solo practitioner or attorney, just him or herself, and there's really no support, that squeaky wheel gets the grease, and so you have to constantly hound them to get work done. Where larger firms have processes in place, right? That there's not just one person touching something, that there's at least an assistant who's keeping you on track or somebody on track, right? So it's important when you think about legacy planning. A part of that is just the nuts and bolts of how do we pass this business on to the next generation? How do we pass our wealth on to the next generation? The farm, the land, the house, whatever, right? And so I wanted to cover today is, how do we choose an estate planning attorney? And and what are some pitfalls? Like, what are some really bad scenarios? Another example I can come up with immediately is an attorney that is working in a space that they're not used to working in. Some of our clients will say, "Oh, I know my son-in-law is an attorney. He'll take care of this for me." Oh, what does he do? He does adoptions.
Right.
It's like, he probably doesn't know a whole lot about how to
That's
transfer
forte.
$10 million to the next generation,
Absolutely. Yeah.
So
we
what are some of your trials and tribulations in that?
Well,
or suggestions?
Sure. Yeah. Well, first of all, thank you for the kind words you said about our firm. And I think, what I suggest folks to look for when they're looking for an estate planning attorney is one of the more important things is exactly what you touched on: having the resources, having the infrastructure to be able to handle what's needing to be done. Do they have the expertise in that? I have family members that call me all throughout the country asking me, like, I got a speeding ticket, can you help me? I'm like, I don't do criminal, and I don't practice in Washington State. So just because I'm an attorney doesn't mean that I know everything. I have a specialty that I focus on. Larger firms typically will have more. We have 3 partners that work on estate planning and 2 associates and 2 paralegals. So we have processes in place in which we have deadlines that we set and calendars to set so that things take care of itself in terms of timing. And you don't have to hound us in theory. If you have to hound us, then we're doing something wrong. I think when you go to solo practitioners or that you go to some smaller firms, you're going to run into somebody that is a general practitioner, and that may not be their expertise, but they also might have 3 or 4 different things coming, like trial calendar. They're probably going to be doing a little litigating as well as some estate planning document, as well as maybe some corporate work, and they're kind of spread a little too thin. So while they might be very well and capable, they just don't have the time and don't have the same internal resources. So we've seen a number of folks that have, in the estate context, that have come to us with that very scenario. He was a great guy, met him in a networking group, great guy, friend of my brother-in-law's, something to that effect. But when the rubber hit the road, they couldn't get him or her to turn the work around in a timely fashion, and a point where so we pride ourselves, or we try to, not to necessarily pitch ourselves, but we try to make sure that we're responsive in terms of turning around. Somebody calls or sends an email, we're responsive within 24 hours, and we have the resources and ability to able to do that. So that's kind of the differences between some of the solo practitioners or some smaller groups and a larger type group.
You can see that on the websites too. If you go to a website and it has about us, and there's 2 faces, and then they do 20 things,
Right.
That's probably not the best. Either that or you live in a really small town, which that sort of makes sense. But
I think there are some misconceptions about the relationship someone may have with an estate planning attorney, in that it being a one and done sort of relationship. People often think that I have a will, I have my documents, I haven't talked to them for 20 years. I don't need to,
Right.
thankfully. But once you're in a situation where you have someone who has passed away, and there's a survivor, and they're living off of the terms of the estate, for example, there is a lot that actually goes on from that point forward. And so having a relationship with an estate planning attorney becomes very important, because things change. You know, the environment changes, the need changes, the beneficiaries' lives change constantly. And so when you said, you know, we respond to emails within 24 hours, for somebody who doesn't really have a relationship with, you know, an estate planning attorney, they may wonder, well, what's so important about that? Don't you just get a will and you're done? And I just kind of wanted to bring up the case that it's not really the case.
Yeah, and that's a good point you bring up, because we actually tell all of our clients that, as a matter of course, maybe a practical reason, but also there's also a substantive reason, is, you know, we say maybe every 4 years to let's get in touch, and we calendar our clients when we set up wills, powers of attorney, trusts, and say, let's revisit in 4 years. And we say, you know, every presidential election cycle.
There you go.
And it's not necessarily because you might have a different change in administration, but it's just a good reminder, like, this is another 4 years. Things have changed. It could be tax laws changed. It could be that you've grown your assets to a point where the planning needs to change. It could be, you know, unfortunately, there's fallouts within families, and, you know, you're going to want to change some beneficiary designations. So, yeah, we try to calendar, or we do calendar to have to follow back up with everyone on at least a 4-year basis, because there are going to be things that need to change. And also we try to give some internal letter of instructions in the event that somebody does pass away and the probate process has to start, and who to get in touch with, and who to how that process is going to look, because the executor of that estate is likely never had to have done this before, never had to go down to the probate court and probate the will and make sure the assets are distributed in a way. So it gives them a little bit of comfort. At least we try to say, get in touch with us, but here's what your responsibilities are going to be. And a lot of our clients have taken comfort in that, knowing that it's already going to be a stressful time when someone passes, but to make one of the more challenging things a little less challenging by giving them those instructions.
That's something that, as a financial planner, that we do on our annual review meetings. We have a line item, estate planning, and, you know, lately it's come into play twice. We've had 2 clients move to South Carolina in the last year. Well, they have everything they need for Georgia, but they don't have anything for South Carolina, right? So it's you know, you think, oh yeah, I did that, but you did it for a different state than you live in currently. Mm-hmm. And you should have a will updated for the current state you live in, and power of attorney and medical directive.
Absolutely, because that's a good point. You know, again, talking about what an attorney can do, just because they're an attorney, they can do attorney work. If you go to South Carolina, the laws in South Carolina are different. In Georgia, for example, powers of attorney and healthcare directives are statutory forms that the legislature has basically approved, and these are the forms that are used. You go to South Carolina, it's a whole other set of rules over there. You may have, if you move to a state, you may have an estate tax in that state in addition to the federal estate tax. So there's things, just because you have the will, to your point earlier, Brad, doesn't mean you're good. You don't have to think about this again. There's a chance it might be, but it's important for you to maintain that relationship with the estate planning attorney. And one thing that we do is we don't charge for those consultations. So a new client that comes in, a lot of firms do this, but you come in to have the discussion about your estate planning, what's important. We'll have that initial consultation, hour and a half, and it's no charge, because we get a sense of what you're looking for, what your objectives are, seeing if or B, if there's any sort of a personality conflict, or if this is going to work or not. And then we make a decision if you want to go forward at that point. We do that when we do the 4-year renewal as well. We'll see what's changed, what hasn't changed. Do we need to make any changes? If not, then, you know, you don't owe us any money, but we did and that's another way to kind of engender that relationship going forward with your estate planning attorney. And I think that's something to look for, whether it's with us or if this is another part of the country. those types of attributes in an estate planning attorney are important because it is more than just a transaction. It should be part of your team, part of your planning, part of your family's wealth planning and asset transfer.
If you, let's say you live in multiple states, so you have a home in Florida, you have a home in Georgia, or home in South Carolina, home here. Should you be carrying power of attorney and medical directive for each state? If you're, will wise, you have a domicile. So let's say Georgia's the domicile, but you're in Florida or another state 6 months, 5 months out of the year. Is it that important to have that, or is it the state that you live in good enough?
The state you live in is typically good enough. We don't typically do multiple states in that regard. So
okay,
but it is important when you have in that scenario you're going to have assets in multiple states, and typically to avoid probate in some of the more challenging states, say Florida, you'd want to maybe put some of those assets in a revocable trust, which avoids probate, and the terms of the trust dictate you don't have to go to probate. Florida probate is very challenging; it can be expensive. You have to use a local Florida attorney to go through probate, and you've got to pay for it. Georgia here is typically pretty easy. It has been historically. However, post-COVID here in Cobb County especially, it's been there's just been delays. And so sometimes, probating an estate normally maybe take 6-7 months. Now sometimes we're seeing it's taking 1.5 years, 2 years. So we're seeing folks, some trends, like we were talking about earlier, Brad, some trends is we're suggesting maybe consider doing a revocable trust here in Georgia just to avoid any delays from the probate process that we're seeing from COVID. And some folks that unfortunately, come to us say, I've got some bad, terminal diagnoses. We're suggesting that because maybe this will fix itself over the long run, but right now in the short run, we're seeing some delays that it's just one less thing for your loved ones to have to worry about, knowing that they don't have to probate and you're going to probate, you're going to put the assets in the trust that are the most substantial, the things that you don't want to. It would be a challenge to live without. Maybe not your cars or like belongings, but house, property, things like that.
That is one thing that we see on almost a recurring basis where clients will have gone to an attorney and set up a trust, but then don't transfer the assets into it.
We see that all the time,
don't we? Though, yeah. And it's just the follow through, or I suppose, or that now the work is turned over to them as to how to do it.
They don't understand it.
They don't understand it. They don't necessarily see the value of it. And here you bring up a very good point. That it's to avoid probate. When probate process has slowed down through efforts at the probate court level. People often think that trusts are simply for wealthy people to hide assets and direct assets to different beneficiaries. And think that Kennedy's may be, and that's all good and valid.
They think Kennedys and Rockefellers.
They do, they do. I don't have need for a trust, and they don't know it's necessarily want to go through the added expense of getting a trust along with, especially like a family trust for an estate, Right. But there's value beyond, just the tax avoidance, if you will.
Right. Yeah, and we see, actually, I see some folks on the flip side that don't need a trust, but really would like. They like the idea of saying, "Yeah, I got a trust."
They do.
And I have to talk them out of it. I'm like, "This is added expense. It's going to be a challenge for your family members to get to some of these." And they're like,
"So really relying on the estate planning attorney for your needs is something that is important, but at the same time, the client really needs to understand what and why everything's being done in a certain way." And how does that fit their needs, right?
That's absolutely correct. And I think a good estate planning attorney is going to lay that out and it's going to be very clear and be able to articulate and communicate the reasons for in lay person's terms. A lot of these trust documents and even wills, even simple wills, have a lot of legalese in there that just people's eyes glaze right over and say, we'll say, review your will, make sure that we're doing this in a way, and I lay it out in a long email or lay it out and say, this is what paragraph 1 is saying, this is what paragraph 2 is saying. and they say, "Oh, I read it," and if you're saying that's what it says, because I don't understand the legalese, the legalese is in there, but it's important for you to be able to articulate in a way that the lay person's going to understand, that they're comfortable with what you've done, why you've done it, and they believe that you've done it in their best interest. Because you're talking to, this is generally any sort. This applies to you guys as well. You're talking to some folks. I talk to people that are worth, well over $100 million doing estate planning for them, and then you're talking with folks that have a net worth of maybe less than 500,000. They come from different backgrounds. They're coming at things from a different lens. And you as an attorney, whether it's an estate attorney or a corporate attorney or a litigator, you have to be able to articulate these things in terms that are going to make sense to these folks. Typically, the $100 million person's dealt with this before, and maybe a little bit more sophisticated as it relates to these type of affairs. But you've got to be able to articulate it to those that maybe haven't dealt with this before.
Something that we're working on here is a one-page financial plan. So to digress further, you think about business planning and you write a business plan, it's like 14, 20 pages, right? That's how they taught us in college, which is like the wrong way. My business plan's on one page, and basically it's got everything laid out, right? The growth rate, the rocks we have to move to get to that growth rate. Well, in financial planning, we do the same thing. We give them 80 pages. It's a PDF now. We have a portal they can log into, so you can log into your own portal, see where you are. You connect all your accounts. It's a living document, like literally every time you log in, it's updating itself. So that was a progression. But really, in the end, what I want to know, if I was doing financial planning, is what are my action items? Like, what do I need to do to make sure what you're telling me on the screen is actually going to happen, right? And so I think on a one-page plan that says, okay, here's all the details, and that's for the engineers and the pilots, right? And for everybody else, here's your action. We try to do that with estate planning. Sometimes when people go, I have no idea what this thing says, we'll just read through it, and then we write down a summary of this is who the beneficiaries are. Right. This is their percentages. This is who's in your power of attorney. And so you write those out, and then people will go, yeah, that's not what I want. And that's okay. Well, I'm gonna connect you with Doug. but for estate planning, sometimes I wish it's like, man, this thing's like this thick. It'd be nice if we could just have a summary. If there's a trust summary on top, but not the trust certification, or not the what's the other one?
Yeah, like a memo of understanding.
Just
this is what it
written
says.
By your secretary, right. Not written.
Well, that's what we try to do. We try to do it. We try to do that in an email if we send the docs via email, or we'll do it in a memo and say, this is what paragraph 2A is saying. Your beneficiaries are A, B, and C. And
make it simple.
Yeah, try to do that. But.
So, getting back to our theme for the quarter with legacy planning, and this is something that's not normal. I don't want to put you on don't mean to put you on the spot, but when people come in and sit down with you, I know they're saying they want to transfer assets. They might be talking about maybe some charitable giving along the way through the process, or they're doing it now. But do you ever have clients ask you, how do you teach my grandson about money? Or how do I teach my kids about money? They're just going to blow through this. Do you ever get into those conversations?
Not too often in terms of how do I teach them about money. However, when we're talking about trust planning, it comes up very frequently that there are these spendthrift provisions that you can put in trust, basically, essentially limiting how much beneficiaries get at certain ages. And in those provisions, sometimes we can articulate, if you are I've done one a couple of years ago, where it was, if you hold down a job that pays more than $100,000 for 5 years, then you'll get 2/3 of your. He was very specific, very specific. And then in his job was, I'm going to try to, try to teach him what's important, let him know that these clauses are in there, and try to get him to grow up a little bit, basically is what he said. So, but they don't really ask me in terms of how do I teach, but they do want to know that there are levers that can be pulled in terms of limiting certain folks. There are family members that may have issues, whether it be, sometimes it's chemical dependence, and they don't want to give them $250,000 so they'll put provisions in there and create it. Again, not an estate planning trust, but not necessarily for wealth transfer, but it could be just a trust to make sure that this individual, that a trustee is making sure this person has enough for health, education, maintenance, and support, but not a lump sum of $500,000 when they can barely, function in a day-to-day world. So that's typically how we see that in terms of how we're dealing with, once they're gone, how are we going to kind of protect the child from, or the beneficiary from themselves.
Interesting. Have you ever, has anyone ever asked for like a family covenant to be drafted, or anything along the lines of, this is how we're going to operate as a family? It's probably not a lawyer function. It's probably more of a business type function, but
we put those in some wills and in some documents. Basically, it's not necessarily legally binding, but it is,
almost like a mission statement.
It's a mission statement. That's a good way to put it. I'm working on one right now, actually, where a gentleman that has no children, but he goes on a fishing trip with his 5 best friends every year. And he says, if I pass away, I want X amount of dollars to go to these guys for the fishing trip. And I said, it's not, they can really do what they want legally with the money,
right?
But he's going to have it written and he's going to add his own verb, he's going to write a funny, heartfelt part of the will that will attach to the will. Will attach a piece of paper,
just like the movies.
Yeah, and he's going to say, this is what it's for, and this is what it's meant to me for so long, and this is the X amount of dollars, and I want you guys to keep going on these trips with me. So, again, not so much legally binding. You get the cash, you get the cash. If you want it to be legally binding, you'd have to put it in a trust and have a trustee, dictate when it can be, which would be very expensive and just unwieldy.
Trip would get real expensive.
Unwieldy, yeah. So, but that to your point, yes, we see things like that where you're putting in a mission statement, or this is what my intentions are, this is what I want it used for. So yeah, we see that from time to time.
So kind of an add-on question to that is, are you seeing a trend, or when do you recommend to bring the beneficiaries into the process prior to the event itself, where the passing?
Mm-hmm.
Are we seeing more of that? Because it's always been a very private thing.
Agreed. And I've seen it both ways. I see it from one extreme of, it's my money, I don't want them, I made all the money, they'll get what they get. If there's any left, great. I mean, the best estate plan is, the joke in the estate plan is, the best estate plan is to spend all the money yourself, right? There's no issue. Yeah. But so sometimes they don't want it. And I guess it's just depending on how they feel with their children or their beneficiaries are going to do with the money. I think those that they find responsible, they'll let them know. Older generation still keeps it pretty private. Younger generation, I've seen bring the beneficiaries in and explain exactly what's going to happen, because they see that they want them to know in the event something happens who to get in touch with and what's supposed to happen, not just be surprised and have no idea as to what things were going to occur. So I'd say now, to answer your question, I think in my practice, and maybe because I'm on the younger side of things, I see most folks bringing in the beneficiaries and at least explaining, you're going to be the executor, you're going to be the trustee. I get a lot lately where they're like, but if I name this person the trustee and not her sister, then they'll get hurt. So I'm going to have a conversation with them and let them know, see what makes the most sense. So I think it's opening up a little bit in that regard. But you still see some that say, it's none of their business. I made all the money. They'll get what they get, and they'll figure it out when we pass.
I met with someone recently that seems to have like a family history of sisters just not getting along, and one sister had sued the other sister over an estate that was very clear 50-50, but she didn't believe any of the numbers that were put in front of her, and so the whole thing got litigated over a couple of years. And then they tell me that their daughters don't trust each other And they're like, well, we're not sure what to do with our assets. And I said, what I would do is the opposite of what your dad did. I would be very transparent. And I would say, these are my assets. They don't have to have access to them. They don't have to know exactly where they are, but we can do a balance sheet and say, these are my assets. And we can have like an annual family meeting. I did that for clients, passed away, I guess, about a year and a half ago now. And it was interesting because one son thought that there should be more money there. Like, oh, where's all their money? Mm-hmm. And then the daughter was like, oh my gosh, they've done so well. So you build things up in your head.
Right.
So one thought, oh man, mom and dad have spent a lot of money on us. We don't have any money left. And the other guy's like, well, because mom and dad spent so much money on us, they must have a ton of money.
Right. Yeah.
And so what was interesting is going through that process for about 5 years. It really made the family work together better as the parents aged, because instead of calling me up going, well, how much money? They don't know anything now. Instead, they were calling me up going, hey, I know this in-home care is costing them $120,000 a year. Are they going to be okay? Can you run that calculator you showed us a couple years ago at dinner? Can you run that calculator? And so it puts everyone on the same page, I think, with transparency. Mm-hmm. Now you still run the risk of, I think, a beneficiary going, I want mine now. And I've seen that too. And to me, that's always really sad to think that, their whole thought process was, well, I'm not as good health as my siblings, and so I deserve my inheritance now. Mm-hmm. And I'm just sitting here going, I'm pretty sure this is like in the Bible, right? The story in the Bible. I want my inheritance now.
Yeah, there is.
So it could backfire. So you kind of have to know who your audience is.
And that's I think it's a case by case scenario, and hopefully the parents have a good feel on whether it makes sense or not. I think it's a double-edged sword, letting your children know how much is coming their way. Right. If it's a lot, they might be less inspired.
I'm about to say, it doesn't mean that's what's coming at all.
If it's not a lot, then they can make plans. I've seen it, and I've seen it in a lot of different ways. I've seen it where folks they've told their children thought that they were getting more and realized they needed to hump it a little bit more. Right. They weren't going to be retiring at 60, and it's a case by case issue. But I think all things being equal, I tend to agree with you in terms of being transparency, or having transparency with regard to that. Yeah. But it just depends, really. It's better some scenarios don't let them know.
Yeah, possibly. And I don't know. It goes back to legacy planning and our interview with James Hughes, and it's almost starts like when they're 5. Honestly, it's teaching them to be the first generation that's making the change, right? As opposed to the second generation that kind of coasts, and the third generation that squanders it. Mm-hmm. I think it's so hard. It's so hard to do that. I mean, even with my own children, helping them understand the value of the value of money. Our listeners, I've told this story already, so I'll kind of, I guess, update them. But I'm having my daughter. She needs a very expensive saddle to get to her next level of horseback riding, and I'm like, this is crazy. Like, it costs more than my son's first car, right? And so I told her that she had to volunteer 20 hours, which she's starting to work on that. And then I told her she had to take a Dave Ramsey course. And so if you have adult children, there's a self-study adult version Dave Ramsey's called Financial Peace. I think it's $80 to take the course. But for teens, it's like a $30 course. And so I had her sign up. I think it's probably 40 plus hours. It's like a whole semester's worth of work. You would get high school credit for it if you did it in high school.
Oh, wow.
And, I thought I was doing so well because I was on a golf trip with my son. I was checking in on her. She went away for about a month to a friend's farm, and she called me. She said, I've been watching these videos and reading the PDFs that are part of the class. And she goes, did you know the first debt was in 1917 with General Motors when they started to tried to sell more cars than Ford. They allowed people to borrow, and Mr. Ford was totally against it, and he wasn't willing. He didn't think people should borrow money to buy a car. If you can't afford to pay cash, you couldn't buy it. And eventually, he had to succumb to financing, and that's where it all kind of started. And I said, yeah, I've heard that story. And I was thinking, oh, great, she's like, I didn't know that. And then she immediately switches into, why do I have to know this stuff? I don't understand the purpose of any of this stuff. I was like, oh,
why don't we just get a loan?
So close. I was so close. But she's making progress. She's listening to the courses.
It'll click.
And I think it'll click eventually, but I know somewhere in there, there's a whole section on don't get student loans, don't borrow money to go to college, don't ask your parents to pay for your college. You should earn it yourself. I don't know that we're on that track, but
expect pushback on that.
It's that pushback on that one. And then essentially what I've done for my son is I've offered the same thing. I said, I've given him a dollar amount. I said, hey, I'll pay you X amount of dollars to take this course. He's like, really? And I was like, well, essentially your sister's getting the same thing and an equivalent and a partial of credit for a saddle that she needs to go to the next level so she doesn't fall off. And he's like, yeah, I'll do that. We'll see if he actually does it. It's going to be a requirement at some point. At some point, the dollar value is going to come down, right, and the pain's going to go up. But
sure.
I think Dave Ramsey has great financial piece is great for learning the budget and learning how money works. And so many people, oh my gosh, not our clients. Our clients don't really need credit scores necessarily, but you why do we have this loan? I have this loan so I can increase my credit score. And you just kind of shake your head like, you don't need a credit score. You just need to, right. You need to stay debt free. You'll still get a mortgage. Like almost anybody can get a mortgage, right? They've made that really super easy, but no, you don't need to escalate it. I think the average car price I saw was, or not car price, but the car payment was around $680 now with this big increase. So now it's $680, but that's one car. So if you have two cars, which most people do, they're paying over $1,300 a month in car loans.
My goodness.
That's insane. Brad, your first house probably didn't cost you $1,300 a month.
It probably did. I love that house.
But yeah, so I think it's part of, you only do so much in nuts and bolts of what you do to change the next generation. It really takes someone in the family nurturing and educating children, and then the next generation about investing and about just being good with the dollar, right? So it's as I always tell people, you make all the mistakes in your 20s, you realize it in your 30s, and you have to pay for it. And then by the time you get to your 40s, you're well underway. So if we can get a generation that can get it right in their 20s,
right? Yeah,
those are multimillionaires.
Yeah, exactly right.
Easily.
I think that's right. Yeah,
easily. Yeah. So, anything else you want to add?
No, I mean, I think
I want to throw a topic out there.
Sure.
Our wills are kind of like our last communication we have with our beneficiaries and our loved ones, aren't they?
In a sense, you can make them, you can customize them to be that way, in a sense, I suppose. Mm-hmm.
So it's really an opportunity. People may think of it as something that's awful, that they don't want to do, but they're missing the concept of it's an opportunity to have your last words with your beneficiaries. It's not just how to divvy up the pie, okay? This is the pie, and this is for you, right? And it's an opportunity to share some thoughts and some, expressions that the deceased may have, with their beneficiaries, their wives, their spouses, their children, their grandchildren, and so on. So I would just suggest that people think of it more in terms of it's not just planning for your demise, but it's planning for what you want your legacy to be, because that's what this is all about. And how do you want to express yourself within that legacy? And that can be done through the will. And the attorney, you guys can help with that, right?
Yeah, absolutely. I mean, typically we in the will itself, you don't see much of that as much, but you do in sidecar documents called letter of instructions sometimes, where you're articulating specific items, family heirlooms. I want my daughter to have all the rings. I want my son to have all my grandfather's guns, and very specific bequests within. And there you can obviously articulate, these guns remind me of the times that we went hunting together for growing up, and all the great times that we spent. One that I had was, he did articulate that gun when we were out hunting, is when you told me you were going to marry. I can't remember her name, but get my point. Like, these items that I'm giving specifically to you are important to me, and I want you to have them. And here are the memories that are tethered to those things. And you can take advantage of that with the wills and these letters of instruction. So I think that's a nice point that you make there. It doesn't have to be all business and cold and black and white. You can make it as one of your most loving acts that you do for your kids. Because even if you don't have a tremendous amount of estate to transfer, in terms of, people think about it, I don't have a whole lot of money to transfer, so I don't need a will. You do have the ability to do what I just said, pass on family heirlooms via the letter of instructions, but you also take one more thing off their plate while they're grieving. One less thing. It makes the transition so much easier, and especially in some of these other side states where it's a real challenge. Georgia, again, not that challenging with probate, but it makes things easier to transition for them to start their life without you. And it takes out a lot of the squabbling that can come between, you made a very nice point, but also there's the reality of the situation is folks will say, my kids are great. They're never going to fight over my money. I don't need a will.
Oh, geez.
I see that go sideways more times than I'd like to talk about, because sometimes the mom and the dad are the glue that are causing the siblings not to fight. And once they pass, they're ready to go at it.
Yeah, absolutely.
So, they aren't fighting in front of mom and dad because they love mom and dad and don't want to upset them. But once they're gone, they're fighting, and they're going to fight over every little thing, especially. And money is the root of many, many evils. So it is a loving, while it's not anything anybody wants to talk about or think about, and there's a lot of things that I ask in the session that they're like, oh, I never thought about that. I guess I got to really think about it. If my wife predeceases, where do I want the assets to go, and in what percentage of things that they just thought it was a rote document. So there's things that have to be thought of, but it's putting in that thought and time gives you the ability to articulate, like you said, Brad, the loving letter, loving statements in the letters of instructions, but also it takes this uncomfortable process of probating and accelerates it, streamlines it, so that you can get on with the next chapter of life. And we all have to do that. So it can be a loving act, one of your last communications.
That's a great way to end this podcast. If you like to hear more work with Doug, you can. His bio is linked in our show notes anywhere you listen to this podcast. We also have a couple of recent podcasts that you should listen to. Episode 116 and 117. What is generational wealth? How do you preserve it? And then also striving to leave a purposeful legacy. Reminder, you can watch this podcast on our YouTube channel, A Wiser Retirement. You can search for that right there in your YouTube search bar. Be sure to subscribe to the page so you can get updates. You can see our Wiser Media Room instead of our YouTube, or instead of our Zoom channel or Zoom podcast, whatever you call those things. Behind me today, actually, we have a bull and a bear. I think this is their featured episode on the podcast. This was done by John Knox, local artist here in Marietta, commissioned through the DK Gallery right here on the square in Marietta. Hopefully we'll have them on a podcast for a 2-minute interview here shortly. Anyway, so yeah, take a look. And guys, enjoy the conversation. Talk to you again soon.
Thanks, Brad.
Thanks,
Casey.
Thanks, Doug.
Enjoyed it.
Thanks for listening to a Wiser Retirement podcast. We hope you enjoyed today's episode. Make sure to subscribe wherever you're listening, that way you don't miss any new episodes. We would also appreciate if you could leave a rating and review. If you have any questions about anything that was discussed today, head to wiserinvestor.com and reach out. We would love to hear from you. This episode was produced and edited by Lilton Moore. This podcast is strictly for informational purposes only and is not to be considered as investment advice or a solicitation to buy or sell any financial products, securities, digital assets, or any other investment vehicles, or a basis to make any financial decisions. Wiser Wealth Management Incorporated is a registered investment advisor with the SEC. The host and/or guest may personally own securities, digital assets, or other investment vehicles mentioned on this podcast. Neither the host nor guest of the show are compensated for their participation, and no referral fees are paid to or received by any host or guest for clients, listeners, or similar interests. Investments involve risk, and unless otherwise stated, are not guaranteed. Be sure to first consult with a qualified financial advisor, tax professional, insurance professional, and/or legal professional before implementing any strategy discussed herein. Past performance is not indicative of future performance.